everybody. Welcome back to the Consumer Warrior Podcast. My name is John Skiba, and I'm a consumer protection attorney in the state of Arizona. I'm also a Ramsey Solutions Master Financial Coach, and I help people to get out of debt. And in today's video, I want to talk about written discovery questions that you receive in debt collection lawsuits. Now, if you have been sued by whether it's an original creditor, like say American Express, Discover, Capital One, or a junk debt buyer like Midland Funding, Portfolio Recovery, Cavalry SPV, or many of the host of other junk debt buyers out there, there's a good possibility that one, you're representing yourself, and two, that the creditor, the plaintiff in your case, is going to send you something called a written discovery request while your case is pending. Now, over 95% of collection lawsuits end in a default judgment, and that's because people don't know what to do as far as how to respond to them. But of those that do respond to them, less than 1% are represented by attorneys. So most people that are fighting this battle are doing so without the benefit of counsel. And because of this, what I have seen in my practice is that the attorneys for the creditor, for the junk debt buyer, whoever they're representing, will often take advantage of that. They'll use that to their benefit in trying to get a judgment against you. And one of the ways that I see that they do this, and I've seen this most recently in a couple of cases here in Arizona, is by the types of written discovery requests that they send over to you and want you to respond to. Now, in any civil lawsuit, the parties are entitled to ask each other questions, written questions, and request documents. These generally fall into three categories. There is a request for production of documents, written interrogatories, and requests for admissions. These are usually three separate documents, three separate requests for information. And I want to go through what each one of those is, just so that you have an understanding of how you need to respond to it. Now, the first one that's most obvious is a request for production of documents. If there's specific documentation related to your case, they can request that from you. It's also true on your end. You can request documentation from them, like monthly statements, the underlying terms and conditions of your agreement. All those types of things you can send over requests, and the parties have to respond to it. The next one is written interrogatories. These are simply written questions that the parties can send to each other where they want to get additional information. And then the last category is the request for admission. Now, these are a little bit tricky, and this is where many of the creditor's attorneys try to use this against you. In that, requests for admissions appear fairly simple in that they state a question, and then they want you either to just admit it or deny it. Those are usually the only two options, to admit or deny what it is that they are asking you. Now, the tricky thing here is in most states, if you don't respond to the request for admission within the required time period, the court can deem those requests admitted. So if you don't respond to it, if you just ignore it, and they ask you, one of the questions is, do you admit that you owe this debt? The court can then deem that you have admitted that by failing to respond to it. So you need to find out how many days you have to respond to the request for admission if you get served with those, and make sure in particular that that one is on time. Let me tell you something else that I'm seeing that causes me a lot of concern that some of these creditors' attorneys are doing. I have some requests for admissions here that a client that I currently have received when he was representing himself. Now, these are interrogatories and requests for production of documents. And typically these types of questions and the documents they're wanting, they're requesting documentation related to the underlying case so that they can help prove their case. All of that is fine and good. Where these questions start to cross the line is when they start diving into questions about your personal financial situation. For instance, on this one, there were some questions about wanting to know the name, address of your current employer, what your gross monthly income is. They wanted copies of your most recent payroll stub. They wanted a full listing of any real estate that this person owned. They wanted a full list of any personal property this person owned. They wanted copies of bank statements, and they wanted copies of their tax returns for the last 2 years. Now, they do this because people who are representing themselves often don't know that you don't have to respond to that. Those questions, to me, are completely out of bounds. They are not part of the underlying suit. There's nothing relevant who your current employer is or what your tax returns are as far as related to a credit card lawsuit. And so you can object to those specific questions and not provide that information. Generally, what the law says is if you are being sued in a civil lawsuit, unless it has some kind of connection with the underlying case, they don't get this information unless they actually get a judgment against you and then are trying to collect on it. Now, if you go to trial or if you lose a summary judgment and they have that judgment, most states allow for what's called a judgment debtors exam, where they're able to come in and request information on employment, bank statements, tax returns, in effort to try to collect on the judgment. But until they have the judgment, you don't have to turn that stuff over, and you need to submit an objection in response to it. And that's all it really needs to say, is that you object to the underlying question because it's not relevant to what it is that the lawsuit is about. So something to be careful of. Don't turn these things over. I see people do this all the time where they just turn it over without even thinking about it because they think they have to. If you have a problem with what they're asking you and it doesn't have anything to do with the underlying lawsuit, like who your employer is or your tax returns, don't provide that documentation or that information. Submit an objection and make a judge decide. If you want to learn more about my practice and about some things that you can do if you're fighting one of these debt collectors, you can head on over to my website at consumerwarrior.com. We have all kinds of templates and forms and even online tutorials, and you can find information about how to contact me for us to help you with your suit. Thanks for watching.